The common law problem from July of 1997 is another of those short fact patterns that can prove to be so problematic. The good news is we don't need to dream up very many issues here. They spoon-feed just about all of them to us. The bad news is here, as is the case with most of the really short fact patterns, we've got to find a home for every last detail, and we've got to be very careful about organizing our thoughts before we start writing. Now, I tell you they give us all of the issues, but they're not doing it in the call of the question. Have a look at it. How should the court decide city's motion to dismiss? Discuss. Well, that tells us almost nothing. This could be a civil procedure problem for all we know. It could be a civil remedies problem. It turns out to be constitutional law, and that fact becomes evident pretty quickly. Let's have a look at the fact pattern itself. Go to the top, and we find out about this city tax ordinance. An annual tax of $500 has to be paid by each household in city with 2 or more children. The tax applies only to people who have become residents since the effective date of the ordinance, and the stated purpose is to reimburse city, in part, for the additional public school expenses and costs of recreational facilities attributable to the new residents. Well, we don't have to go any farther than paragraph 1 to get the idea that there's going to be probably a fairly complicated equal protection claim against this ordinance. We've got 1 or 2 discriminations taking place just in the first paragraph. Read on. In paragraph 2, we meet Paul and Pat, husband and wife. They became residents of city after the effective date of the tax ordinance, and they live alone with no kids. They have filed suit against city in federal court for a judgment declaring that the ordinance violates their rights under the U.S. Constitution to familial privacy, to due process, and to equal protection. Well, hallelujah. They just gave us the constitutional law issues right there. We'll break them up into pieces. We will analyze each one of them as carefully as we can, mindful of the law and meticulous about finding a home for the facts. Now go to paragraph 3. It gets a little more complicated here. During discovery, Paul and Pat revealed that they are medically unable to conceive, but have applied to adopt twins. The court orders this information confidential and seals the record, but city's attorney has disclosed it in a press release. Paul and Pat amend their complaint to allege another claim against city that their disclosure violated their privacy rights under the U.S. Constitution, entitling plaintiffs to an injunction prohibiting further disclosures and allowing the court to impose sanctions for violation of its confidentiality order. Now that's a fairly tricky issue, and it will bring up a topic that we saw way back in our consideration of remedies, a relatively obscure doctrine known as the collateral bar rule. That's a bit of black letter law that you are going to pick up for sure during your work on the master essay method, even if you've never seen it before, because it's tested not that infrequently. Now we get the city's motion to dismiss on a couple of different grounds. First, that the plaintiffs lack standing, and secondly, that even if they do have standing, none of the alleged constitutional violations have taken place. And then we get the call of the question again. How should the court decide city's motion to dismiss? Discuss. Well, let's take everything they gave us and organize it into an outline. That's the best way to respond to any fact pattern, and it certainly allows us to make reasonably short work of this not uncomplicated question. First, we focus on the standing issue. I give a separate section in the analysis to standing. I focus on the Article 3 case and controversy requirement, and I have a separate section on the facts. First, that these parents don't even have kids, so they're not parents yet, and that they have applied to adopt. Next, we consider taxpayer standing, ripeness, the 11th Amendment, and we reach a conclusion. It seems to me that this section is the most difficult part of coming up with an answer to this fact pattern. The standing analysis in isolation is pretty straightforward and simple, but going the extra mile to consider Article 3 and taxpayer standing and the 11th Amendment is what turns a mediocre and thin answer into a masterful, complete, thoughtful answer. So once again, we see that in con law, as elsewhere, really having a clear notion of how the material is tested and a good checklist of issues can be enormously helpful when it comes time to spot the issues under time pressure. Next, we consider the constitutional claims of the plaintiffs. Substantive due process is the formal name for familial privacy's constitutional law protections. Procedural due process we'll consider as well. Anytime we get a broad discussion of due process in a fact pattern, our instinct will be to have separate sections on substantive and procedural due process. It looks as if this is much more of a substantive due process problem. Then we consider equal protection, and even here in the heading, I indicate 3 different discriminations: those with children versus those without, those with a high number of children versus those with a lower number, and the duration of residency. When we're dealing with equal protection, it's appropriate to recite as many different discriminations as we can spot and to consider each one of them separately. Next, we consider the injunction and sanctions issues. Here we focus on the collateral bar rule. We juxtapose that with a consideration of the restriction on First Amendment speech that the underlying order does represent, and then we reach a bottom line there. So once again, we see that organizing our approach to the answer is what will guarantee that we've got a chance to do a thorough job. It's always a good idea to invest just about whatever time it takes to organize our thinking so that our answer can proceed almost as a series of short answers that will add up to a coherent whole. So now let's have a look at my answer for a couple of minutes, and we'll focus first on standing and the case and controversy requirements of Article 3. Here, for once, I actually lead with a little bit of law. Paul and Pat must show they have suffered a redressable injury in order to defeat this motion. And I suggest that, as I discussed below, they face a threat of an imminent injury. They can show state action, injury, and causation. So the court should address these claims. Next, I focus on the most specific facts. First, that they don't have kids, and second, that they are medically unable to conceive. I explain the facts, and I indicate that if their application to adopt twins is denied, then the case will in fact be moot, and they won't have standing. But assuming that this application is going to succeed, they certainly do have standing to contest this issue. Next, I have a little section on taxpayer standing, and maybe this is a little bonus add-on that doesn't really need to be there. But notice, I don't waste a lot of time on it. I put it in here just to indicate that this is not a taxpayer standing question. I distinguish the body of law that it really is being tested from one that is not actually relevant, and I only do it in 3 short sentences. But I think you'll agree that this little section on taxpayer standing enhances the overall value of the answer. And the reason for that is it shows a somewhat broader understanding of constitutional law issues, and it allows us to distinguish one body of law, the one that we are really being tested on, from another, somewhat related body of law that's outside the question. Next, we turn to ripeness, and here we focus again on the facts. We move on to the 11th Amendment, and here we recite the law very briefly. The 11th Amendment prevents suits in federal court against states, except under very narrow circumstances. And here, the 11th Amendment is no problem, because the plaintiffs are suing city rather than state. So the city can't use the 11th Amendment as a defense. Is this issue necessary? Well, probably not. But I do think that once again, it's important to distinguish the body of law that applies from ones that don't. And so here, we've got private plaintiffs suing a municipality. We distinguish that, which is legitimate, from a private plaintiff suing a state in federal court, which is barred by the 11th Amendment. Trust me, it's worth knowing the 11th Amendment, and it's appropriate to be ready to use it when appropriate on a California bar essay. So the bottom line for this analysis is the city's motion to dismiss on standing grounds would be denied. Next, we move on to what I think we can agree is the core of this problem, the constitutional law theories presented by these plaintiffs. First, we focus on substantive due process. and family privacy. Here, the right to privacy involving child rearing, childbirth, is a fundamental right, and so any law that interferes with that right will be stricken unless the legislation is necessary to achieve a compelling government interest. And this ordinance doesn't survive strict scrutiny. There are less restrictive ways for the city to accomplish this goal. The goal is to partially reimburse city for additional public school and recreational facilities which are being offered to all residents. It's a desirable goal, but it isn't a compelling interest. Plus, there are other tax setups that could be arranged that don't infringe on fundamental constitutional rights. So, Paul and Pat's substantive due process claim obviously has got merit, and a motion to dismiss should be denied. Next, we focus on procedural due process, and here, these plaintiffs don't have a real procedural due process claim. They aren't being deprived of liberty and property that can be redressed with notice and a hearing. In fact, it looks like they got good notice that this lawsuit is a type of hearing. So, again, we include procedural due process to distinguish it from the body of law that really is being tested here. And notice, we weren't told to limit our analysis, and so we broaden it just a little bit, again, to show that we're really thinking about the broader context of how con law issues get litigated. Next, we turn to the equal protection claim. And here I indicate, right up front, the three different discriminations that this tax ordinance has within it. I list them and I number them. Then I argue that the equal protection claim is weak. The expenses of the city have gone up for new residents. The financial condition of the city is a legitimate government interest, and the tax on new families is certainly rational and related. In order to win an equal protection claim, Paul and Pat would have to use a fundamental rights theory, which is inherently related to their substantive due process claim. Still, the right to travel or vote is not being interfered with here. I'd apply rational basis and dismiss their equal protection claim. Then finally, we turn to the injunction and the sanctions. And here, once again, we see this fairly obscure doctrine which has made its way onto the California bar more than once in recent years, and that's the collateral bar rule. And here, we focus on the facts up front. The court previously ordered that Paul and Pat's infertility and adoption application be kept private. That's a lawful court order, and the city should have appealed the order if they objected to it, but they didn't. Instead, they just directly disobey the order, and they don't have a First Amendment argument to attack this order as being void on its face. So the city should have appealed this issue rather than just ignoring a court order. So the collateral bar rule is going to prevent them from using the First Amendment to try to escape liability for contempt. Then I have a brief section on the First Amendment restriction. The court has sealed all these references to Paul and Pat's infertility and their application to adopt. It's a prior restraint, and it's subject to strict scrutiny. But here, we do have a compelling interest in protecting the privacy of these plaintiffs. And although it is likely that a court would uphold the restraint, the collateral bar rule makes this finding unnecessary because we had a lawful court order that was violated without any pretext and without any legal niceties. And that's just not legal. And these guys are going to be subject to sanctions as a result of the collateral bar rule. So that wraps up a consideration of another tricky con law essay question. They told us what all the issues were, but we had to have a broad knowledge of con law in order to provide a rich, thorough, analytical answer to this tricky fact pattern.